India Legal presents Courts Roundup.
Supreme Court has extended the parole by a week of A.G. Parivaran, a convict in 1991 assassination of former Prime Minister Rajiv Gandhi, and has directed State of Tamil Nadu to provide an escort for his medical checks. A bench headed by Justice L. Nageshwara Rao heard the submissions of senior advocate Gopal Sankaran Narayanan, who requested the court to direct the state to extend the parole of Parivaran by a week.
Justice L. Nageshwar Rao-led bench of the Supreme Court extended the parole granted to A.G. Parivaran, convict in the Rajiv Gandhi assassination case, by a week. The top court also directed the Tamil Nadu government to provide escort to Parivaran so that he can attend medical checks. The order was passed after senior advocate Gopal Sankar Narayan informed the bench that Madras High Court had earlier extended the parole from November 9 to November 23. Sankar Narayan referred to the Nilofer Nisha judgment where the Supreme Court stated that mercy petitions have to be decided in a time-bound manner. The senior counsel submitted that the governor is bound by the recommendation of the state government. The bench of Justices Rao and Ajay Rastogi was hearing a case seeking remission of sentence of Parivaran. The court has now slotted the case for final disposal on the next date of hearing. Earlier, the apex court had on November 3 said the MDMA investigation into the larger conspiracy behind Rajiv Gandhi assassination need not deter the Tamil Nadu governor from deciding the plea for pardon of convicts like A.G. Parivaran, who have been serving the sentence in jail for over 2 decades. The Central Bureau of Investigation also told the Supreme Court last week that the governor of Tamil Nadu is the competent authority to take the request for remission. In an affidavit filed on November 20, the Central Investigating Agency maintained that the issue of remission of sentence is solely between the office of the governor, Banwarilal Purohit, and the convict. It is for the governor to decide whether or not to release Parivaran, who is serving a life sentence. The reply from the agency came after Parivaran's mother applied to the Tamil Nadu governor for his release. CBI also told the Supreme Court that Parivaran is not needed for further investigation conducted by its multidisciplinary monitoring agency or MDMA into the larger conspiracy behind the assassination of former Prime Minister Rajiv Gandhi in 1991. The Additional Solicitor General of India, K.M. Nataraj, told the bench that investigation on the angle of larger conspiracy was spread over foreign countries such as United Kingdom, Sri Lanka, and that the CBI was waiting for replies to the rogatory letters sent to foreign jurisdictions. At this juncture, Justice Nageshwar Rao told that the probe into larger conspiracy was related to some other person who may be involved behind the Rajiv Gandhi assassination case and that it was not related to persons who have already been convicted and been spending time in jail for past 28 years. The Supreme Court had said in 2018 that it's up to the governor to decide on. Parivaran had applied to the governor for pardon on December 30, 2015. Almost 3 years later, in September 2018, the Supreme Court asked the governor to decide the pardon plea as he deemed fit. 3 days later, on September 9, 2018, the Tamil Nadu cabinet recommended to the governor to remit Parivaran's sentence and release him forthwith, but the governor yet to take a call on the same. The Jain Commission of Inquiry into the assassination had in 1998 recommended further probe into the Rajiv Gandhi killing. It mandated including monitoring and tracking of absconding persons suspected of crime, probe into the role of 21 Sri Lankan and Indian suspects identified by the Commission, looking into the delay in the interception of messages, among other things. Bureau Report.
The Supreme Court has expressed alarm at worsening COVID-19 situation, particularly in Gujarat and Delhi, and sought details of steps taken by governments in those states to tackle the crisis. A three-judge bench of Justices Ashok Bhushan, Mr. Shah and Subhash Reddy also asked the states of Maharashtra and Assam to apprise the court of steps envisaged to manage the crisis. Justice Shah, who hails from Gujarat, took exception to state's management of problem. Counsel for Gujarat said that status report would be placed before the top court immediately. Regarding Delhi, the bench was informed by Additional Solicitor General Sanjay Jain that compliance affidavit had been filed before Apex Court by AAP government on July 22, adhering to its earlier directions. However, the court asked what steps the Delhi government was taking to deal with recent spike in COVID positive cases. To this, Additional Solicitor General Jain apprised the court that with rise in demand for beds in private hospitals, all 115 private hospitals have the 80% beds reserved for COVID patients as compared to earlier notification, which had only 33 such hospitals under reservation ambit. Solicitor General Tushar Mehta, representing the central government, submitted how it was unfortunate that Supreme Court had to deal with an issue of managing dead bodies. This is unfortunate for humanity that you have to deal with this, said Mehta. The court said in its order that Solicitor General submits that Union Home Minister has taken steps to improve the situation in Delhi. He will file an affidavit regarding status of COVID cases in country, especially Delhi. Situation this month is likely to further worsen, and thus state governments have to gear up for the situation, and action needs to be taken. It's the victory of our nation that women aspire to achieve the highest pedestal, remarked Justice DY Chandrachud, has remarked. In a significant judgment on gender equality verdict delivered on February 17, a bench headed by Justice Chandrachud had directed that permanent commission should be granted to women in army regardless of their service. In all the 10 streams where union government has already taken decision to grant short service commission to women. The remark came when senior advocate R. Balasubramaniam, having represented the Union of India in aforesaid matter, informed the bench of Justices Chandrachud, Indu Malhotra and Indira Banerjee that 70% of women officers have received permanent commission pursuant to court's judgment. Yes, I believe some 450 officers got it, said Justice Chandrachud. That may be because many of them qualify for pension. But that is the choice of women officers, whether they want it or not. The fact that 70% of them got it shows that they are dedicated servants, fit at this age also, as against the contention that was raised, observed the judge. Yes, it is path-breaking, said Mr. Balasubramaniam. It is a victory for our nation that women aspire to achieve the highest pedestal. It is a great feeling even for us as judges. This is what makes our life complete, said Justice Chandru reportedly. Almost 70% of women officers who were considered for permanent commission in army by a special selection board have been selected to serve a full term in the army. The Delhi police has filed a supplementary charge sheet in a court here against former JNU student leader Umar Khalid and JNU student Sharjeel Imam in a case related to alleged larger conspiracy in communal violence in northeast Delhi in February. The charge sheet was filed before Additional Sessions Judge Amitabh Rawat against Khalid Imam and one Faizan Khan under the stringent Unlawful Activities Prevention Act and sections related to conspiracy, murder, rioting, sedition, unlawful assembly and promoting enmity on grounds of religion, language, caste, etc. of Indian Penal Code. The offences entail a maximum punishment of death penalty. The 930-page supplementary charge sheet was filed under Section 13, Unlawful Activities, Section 16, Terrorist Act, Section 17, Raising Funds for Terrorist Act and Section 18, Conspiracy of UAPA. The accused have been charged under IPC Sections 120B, Criminal Conspiracy, read with Sections 109, Abatement, 114, Abettor Present when offences committed, Section 124A, Sedition, 147 and 148, Rioting. While Khalid and Imam are currently in judicial custody in the case, Khan had been granted bail by Delhi High Court. The main charge sheet was filed in September against Pinjara Tod members and JNU students Devangana Kalita and Natasha Narwal, Jamia Millia Islamia student Asif Iqbal Tanha, and student activist Gulfisha Fatima. The Delhi High Court, while dealing with matrimonial case, has held the false allegation of impotency against a husband amounts to cruelty by wife under Hindu Marriage Act. The wife had filed an appeal before Delhi High Court against order of family court, whereby court, while rejecting the relief sought under section 12(1)(a) and (c), allowed the petition of husband by granting divorce under section 13(1)(ia) of the Hindu Marriage Act 1955. The husband initially preferred a petition seeking a decree of nullity of marriage section 12(1)(a) and section c of the Act, on two grounds: that marriage could not be consummated due to appellant's impotency, and that his consent was obtained by concealing several material facts related to psychological disposition of appellant, knowing which he would not have consented for the marriage. In the written statement filed before the trial court, the appellant wife pleaded that husband was suffering from impotency, which was the true cause of non-consummation of marriage. Placing reliance on wife's written statement, the husband amended his petition and additionally sought relief of divorce on the ground that allegations made in the written statement were false and had caused him mental cruelty. The division bench of High Court, comprising Justices Manmohan and Sanjeev Narula, observed that courts, with respect to allegations made in pleadings, if it is established from evidence that allegations were evidently false, then such baseless allegations made in the written statement can amount to cruelty, and court can pass a decree of dissolution of the marriage. The Delhi High Court has dismissed pleas challenging the legality of Central Bureau on Investigation appeal against trial court's 2G verdict on ground of lack of requisite sanction or approval from central government. The challenge is not maintainable as it is beyond the scope of section 378(2) of the Code of Criminal Procedure, and Justice Brijesh Sethi, holding that this provision did not concern the steps preceding to presentation of appeal by investigating agency, Justice Sethi stated it was enough that appeal was duly filed by Special Public Prosecutor for CBI. The court also held that CBI was not under any obligation to furnish a copy of sanction or approval to file an appeal. Apart from settling the issue of lack of sanction, the court also held that 2018 Amendment to Prevention of Corruption Act, Section 13(1)(d) would not come to rescue of accused in present appeal. Delhi High Court said the amended act does not apply to offences that have already been taken place. There was no intention to obliterate the earlier law. In view of retirement at end of this month, Justice Brijesh Sethi also released the appeals from his board. The appeals will now be listed before another judge. A Mumbai court has granted bail to comedian Bharti Singh and her husband Harsh Limbachia, who were arrested on Saturday by Narcotics Control Bureau for allegedly being in possession of drugs. The bail was granted by Additional Chief Metropolitan Magistrate at Esplanade, Mumbai, subject to furnishing bail bond of Rs 15,000 each. The couple was arrested on Saturday and produced before the vacation magistrate at Esplanade yesterday, where the court remanded them to judicial custody till December 4. Bharti Singh and Harsh Limbachia have been booked under the NDPS Act. During the hearing before the magistrate on Saturday, NCB sought Harsh Limbachia's custody but did not seek Bharti Singh's custody. It was submitted on behalf of NCB that Bharti may be sent to judicial custody. Appearing on behalf of couple, Advocate Ayaz Khan argued that need for custodial interrogation of accused did not arise as the contraband substance recovered is less than the commercial quantity as prescribed under the Narcotics, Drugs and Psychotropic Substances Act. A total of 1 kilogram of ganja is considered commercial quantity as per the NDPS Act. Court accepted Khan's submissions and observed that accused have been questioned at length on Saturday itself by the NCB. The couple's house was raided by NCB after a drug peddler who was arrested in relation to Sushant Singh Rajput death case named Bharti. Actor Kangana Ranaut and her sister Rangoli Chandel have moved Bombay High Court seeking quashing of FIR against them at Bandra Police Station. An order passed by Bandra Magistrate Court ordering registration of FIR taking cognizance under section 156(3) of CRPC for allegedly trying to create a communal divide through their social media. In October, Metropolitan Magistrate ordered an FIR to be registered after finding a case against the actor and her sister. The complaint was filed by one Munawar Ali Syed, a casting director in Hindi film industry. The complainant alleged that by her tweets, Kangana is creating divisions between Hindu artist and Muslim artist. I say that accused number 1 is maliciously bringing religion in almost all her tweets, he alleged. Thereafter, the complaint cited instances wherein Kangana and Rangoli's tweets were allegedly communal. A division bench of Justice S.S. Shinde and Justice M.S. Karnik is likely to hear the matter on October 29. Magistrate Court at Andheri ordered inquiry against actor Kangana Ranaut and her sister Rangoli Chandel for allegedly posting derogatory tweets against the Muslim community. Court ordered an inquiry under section 202 of CRPC and called for a police report on allegations against the siblings. Apart from this, a court in Karnataka ordered an FIR to be registered against the actor for her tweets on protest by farmers against the Farm Bill. That's all for now in Courts Roundup. Keep watching APN.
India Legal presents Courts Roundup.